Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss the case of Mazars Indsil Hydropower and Manganese Limited versus State of Kerala and others. Wherein, among other things, the Honorable Supreme Court considered whether imposition of royalty by the respondent state on use of water by the appellants is justified or not. In this case, the appellant entered into a hydropower agreement with the respondent for generation of electricity. Clause 14 of the agreement provided for imposition of royalty on the appellant for the use of water along with the relevant taxes and duties. It was contended that such imposition of royalty is unconstitutional since the appellants are discriminated against similarly situated hydropower plants where no such royalty is imposed, and that such imposition of royalty would partake the nature and character of a tax which is impermissible without any statutory backing. On the other hand, the respondent state argued that imposition of royalty is legal since it has been specifically mentioned in the contract to which the appellants are signatory. In order to understand the matter in a better manner, let us go through the pertinent observations by the court. Firstly, the court made an endeavor to understand the meaning of royalty by referring to various case laws and law lexicons. In the case of HRS Murthy versus Collector of Chittoor, it was observed that royalties are payments which the government may demand for appropriation of minerals, timber, or other property belonging to the government. And royalty is paid to the owner of the land, who may be a private person and may not necessarily be a state. A private person owning the land is entitled to charge royalty but not tax. The lessor receives royalty as his income, and for the lessee, the royalty paid is an expenditure incurred. Royalty cannot be tax. Secondly, the court also explained the meaning of tax and relied upon the findings of the court in the case of Jindal Stainless Limited and another versus State of Haryana and others, wherein it was observed that a tax is a compulsory exaction of money by a public authority for public purposes and foreseeable by law and is not payment for services rendered. Thirdly, the court clarified the use of the expression royalty in the realm of contracts and relied upon the observations made in the case of Inderjeet Singh Sial and another versus Karamchand Thapar and others, wherein it was held that when contracting parties use the word royalty in a contract, then mere usage of such word does not confer any sovereign rights of the state on the private party to contend that such usage of word royalty makes redundant the rights and obligations that have been created by the contract. Fourthly, the court considered the distinction between tax and royalty. According to the court, the expression royalty has consistently been construed to be compensation paid for rights and privileges enjoyed by the grantee, and normally has its genesis in the agreement entered into between the grantor and the grantee, as against tax, which is imposed under a statutory power without reference to any special benefit to be conferred on the payer of the tax. The royalty would be in terms of the agreement between the parties and normally has direct relationship with the benefit or privilege conferred upon the grantee. Fifthly, the court opined that such imposition of royalty is basically charges for the privilege of use of controlled release of water which helps in generation of electricity by the appellants. For such benefit or privilege conferred upon them, the agreements arrived at between the parties contemplated payment of charges for such conferral of advantage. According to the court, such charges were completely justified. Sixthly, the court observed that Imposition of royalty cannot be termed as compulsory exaction, as it was the result of the contractual relationship between the parties. Therefore, in view of the aforestated reasons, the Supreme Court rejected the submissions of the appellants that imposition of royalty was discriminatory and is akin to a tax. Those were the observations by the court. So, what are my concluding remarks? What is and what is not royalty has been the subject matter of countless petitions, and it has been seen that the contractors, after entering into the contracts, take this plea that royalty is discriminatory and is a tax. The court rightly stated that when a contract has been entered into, both the parties are bound by its provisions. Later on, claiming that imposition of royalty is discriminatory cannot be sustainable before the eyes of law. When a private entity uses the resources of the state, such as water, minerals, or any other commodity, then why should such commodity be given to private entities free of cost? Imposition of royalty ensures that no unjust enrichment takes place by the private parties. If the contractual conditions are so erroneous and discriminatory, then the private parties are always free not to enter into such contracts. But after executing such contracts, the private parties cannot take the plea that the conditions are too onerous, where in fact, what is being done is simply imposition of charges for usage of resources of the state. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.